By virtue of a letter of authority, the CIR authorized a tax investigation on T Company. Hence, T Company received a preliminary assessment notice, stating that it was required to pay a tax deficiency amounting to 92 million pesos. However, after further assessment, the amount was reduced to 7 million pesos, which T Company promptly paid. Following the payment, the CIR did not issue any additional notices such as final assessment notice and final letter of demand related to the tax investigation. 50 days after making the payment, T Company filed a claim for a refund of the 7 million pesos, alleging that the payment was made in error under an erroneous PAN. T Company adds that it never received a FAN or FLD, both of which are required and indispensable. The CIR contends that the tax was neither erroneous nor illegally collected because T Company voluntarily paid the assessment, which constitutes an informal settlement of its tax liability. Is the CIR's argument correct? Explain.
Yes, the CIR's argument is correct. The Supreme Court held that the BIR is not restricted from using less formal methods to resolve tax controversies without resorting to the lengthy process of litigation. This is precisely why the CIR is granted the authority under the NIRC to compromise or abate any tax liability at any stage of the proceedings, even for criminal violations not involving fraud, provided they have not yet been filed in court. Accordingly, the CIR may engage in informal settlements to resolve these cases, as long as they remain within the legal boundaries set by law. Here, under the CIR's authority to settle tax liabilities, an informal settlement occurred when T Company paid 7 million pesos toward the assessed VAT deficiency. Following this payment, notices between the parties ceased, and the BIR no longer attempted to issue an FLD or FAN. As a result, the BIR was deemed to have waived its right to pursue the remaining deficiency taxes initially assessed under the PAN. Thus, the informal settlement is binding and can only be undone in cases of fraud or falsity. Thus, the CIR's argument is correct.